Good morning, colleagues. Eddie, can you just make me a co-host so I can ready to present on the later items? Thanks. It's Adam.
Recording in progress.
Morning, Chairperson and members.
Morning, Eddie. Morning.
Morning. Yes, it's exactly 10 o'clock. We have enough members and also the stakeholders that are supposed to present are here in the meeting. Chair, over to you.
Morning, Mr. Matonsi, and morning, honorable members, all the stakeholders in attendance, the Department of Home Affairs, Parliamentary Legal Services, and the state law advisors, and all the officials in attendance. I'll also request to grant off my video to benefit from the network. And good morning. Today we are going to deal with the items that have been highlighted on the agenda. We are expecting that will contribute to the 3 items that have been identified by the committee. Firstly, in our last committee meeting, we dealt with the budget and strategic plan of Department of Home Affairs and Border Management Authority. Subsequent to that, there were changes, as all of us were aware, in terms of the review of the budget. Today, we're supposed to receive a presentation by Department of or the Government Printing Works and the Independent Electoral Commission. We could not do that given the circumstances of the budget reviews, which we still have to interact with the budget. Hence, today, the 2 items were not going to be dealt with. We then ought to review the program in relation to the key issues that we thought this portfolio committee meeting need to interact with before the budget review. So that's the reason we've identified these items in MENCO. We've also dealt with the issues that in the previous strategic plan that were raised by members, and this also give us and the Department of Home Affairs, including BMA opportunity, reflect on the issues that the members have raised, which will highlight on the in this meeting for noting in addition, so that we formally submit them to the Department of Home Affairs and BMA at the time they are going to present the review stretch plan and the budget. Well, we'll hope that they could have identified or considered some of the issues that we raised. We also note that we have visited Lebombo Border Management Authority, who conducted an oversight to visit on the site of Mpumalanga, and also Government Printing Works as part of our work. And you'll note that we've raised the concern to the staff, which I may need to bring to the attention again, that were supposed to have dealt with these reports and presented in the House earlier on. And I don't think that moving forward, reports of oversight, we may need to see how we are brought before the committee for adoption, and we see how we navigate the program of the committee to allow us to present it to the House. So in future, we may need to, the team may need to be focused because most of the reports, this oversight has been carried now is May. So it's a matter that I've raised with the team and also the head of the team in terms of priorities of the issues. And we'll adopt this report. It's been circulated to us. We've discussed about these reports, and then we'll then move to the issues that I've requested both the research team and the secretary, in particular to the issues of identified in Mthatha, that the response that we have received from the department is not sufficient. I think there's an indication that they're paying this matter into attention, but there's no demonstration. What does it mean? So I've requested the team to interact directly with the complainant, and so that they bring a report and also deal with these issues with the provincial manager to get a clear picture of what it means in terms of the response that have been given. I think the team will deal with that. There was an issue which was raised also of the status of Phil Craig, and I think we've deposited that matter to the ministry. There's a response to that and the follow-ups to that extent so that we get a detailed brief around that in this subject matter. Members, we've also observed current dynamics or current issues that are emerging within our society in relation to the marches that have been conducted, in relation to illegal individuals who have entered the country without following due process. And we've taken note of those issues. It's a matter we've also been raising for over a period of time. And all of us, I think, will agree that the initiative of developing the white paper on citizenship and protections of refugees is as a result of this question that we've been raising over time. And once this white paper has been approved by, the bill has been approved by Parliament, by Cabinet, and be tabled to the committee, and also beginning to formally have a conversation with all citizens around this subject matter. So we're noting these issues, and also the arrest that has been conducted somewhere in Gauteng, which also give confidence to the work of the law enforcement agencies in terms of keeping these individuals who are in the country illegally. And I think this is a collective call of members of the committee, stakeholders, and also the Department of Home Affairs to enforce the work that we've been assigned to do in terms of making sure that we deal with this question. So some of those issues, I think, will emerge as we interface with the bill in relation to the white paper. And I think the committee was resolved in terms of the targets that has been put across. I think when we deal with that item, we'll able to get a sense. Lastly, we concern on the continuous downtime Department of Home Affairs, because it derailed the work that has been put, or the efforts that has been put across. And we think that in the next discussion with the department in relation to the issues that have been raised, we're able to give a more comprehensive plan on how some of these issues and also infrastructure will be dealt with. We acknowledge and appreciate the recommendation of the CSIR, as we have received the report, which give confidence to mitigate issues that have been raised by all members of the committee. I will now invite Mr. Matonsi to run apologies and then I will invite the stakeholders to deal with other issues.
Yes, Chairperson, from my side, I've got an apology from Ms. Mthambi. She said no, she will not be attending meetings for the whole month. She's involved in the interviews of the regional magistrate. And also there's an apology from the minister and the deputy minister. Those are the all apologies, Chair. Hi, Chair. Adam, can you hear me?
We can hear you, Mr. Matonzi. We can hear you.
We can hear you.
Is there any other apology that members want to put across? Or stakeholders? Okay, can we now move to the... Yeah, Mr. Matonzi?
Yes, Chair, I can hear you.
Okay, no, thanks, yeah. We can now move to the third item. Members, you know that we're dealing with this immigration amendment bill, which we have was tabled before the committee. We've conducted oral submissions and written. There was a conversation around that. So we've invited the committee, legal service, the chief state law advisor, and also the Department of Home Affairs to brief the committee on some of the issues that are rising in these discussions. Remember, we have taken a decision that there were issues that were not, there were differences in terms of the provisions that are entailed in the amendment bill that our stakeholders may need to come back to the committee before we'll enter for deliberation. This will give you opportunity to note the issues that will be raised, and also will sort for clarity. Then we'll then have to note the report. We'll schedule for deliberation on this subject matter. Mr. Matosi, are we starting with the Parliamentary Legal Services?
Yes, Chair, we're starting with the Parliamentary Legal Service.
Thank you. Daksha?
Good morning, Chairperson, honourable members, stakeholders and colleagues. I will be making this presentation, but together with me in my office, Ms. Clara Williams is with me, and she'll also assist in fielding any questions that may follow. So, Chairperson, as you rightfully set out the background, the purpose of this presentation is to report on the areas of differences of opinion between ourselves, the Department of Home Affairs, as well as the Office of the Chief State Law Advisor. However, before I go into the report, I just quickly, for the purposes of recapping, I'd just like to present the background. As we have previously discussed, the Constitutional Court in 2 judgments declared and confirmed that Section 34(1)(b) and (d) of the Immigration Act is inconsistent with Section 12 and Section 35(2)(d) of the Constitution, and therefore declared the section invalid. The main findings was that the section was unconstitutional since it did not require an automatic judicial review. It was also found to be unconstitutional because it did not require the appearance of the detainee in person in court before the decision to extend the detention for a further 90 days. And it was found to be unconstitutional because it conferred a very wide power on immigration officers to detain without any objectively determinable conditions or guidance for how that power is to be exercised. Now, in order to address the findings in this judgment, the Immigration Amendment Bill was introduced in Parliament. The bill was published for comment, and a summary of all the written submissions received was presented to the committee. The committee also held public hearings on the bill, at which various stakeholders made oral submissions on the bill. And what the committee also got was a briefing from the Constitutional and Legal Services officers, which is our office, the Department of Home Affairs, as well as the Office of the Chief State Law Advisor, who all considered the public submissions and presented their responses and views to this committee on the 14th of March. At this meeting held on the 14th of March, it became clear that there were some issues on which the CLSO, the department, and OXLA did not agree. At the request of yourself, Ms. Chairperson, the CLSO, the department, and OXLA met to discuss these issues. This meeting was then held on the 17th of March, but following the meeting, it appeared that the issues of disagreement still prevailed. You then, Chairperson, after we briefed you on this meeting, requested that we draft a report setting out these areas of disagreement. This report was finalized by our officers on the 26th of March, and as I understand, a copy thereof was circulated to all members of the committee. Hence, the purpose of this presentation is to very succinctly present the report to the committee. A more detailed explanation of the issues will be found in the report itself. The format then of this presentation will entail a very brief summary of the public submissions on the issue, key findings of the Constitutional Court judgment, but very comprehensive findings that support our arguments are further detailed in the report, but will not be repeated here. The presentation will also entail the CLSOs, the departments, and OXLA's response to the submissions, as well as our officers' reply and our officers' recommendations or advice for the committee's consideration and future deliberations. Before I go into the report, Chairperson, I'd just like to make a few remarks, as we've also said in previous presentations. The 2017 Constitutional Court's judgment has confirmed and stressed that it is the domain of Parliament to amend legislation. It is not the court's function to amend legislation. Parliament is considered best placed to remedy the problem which the court identifies in legislation, and the judgments in its orders enables Parliament to correct the defects by a certain date. The judgments then also state that pending such correction, a certain remedy will apply. Now, the manner in which the 2023 judgment, which was a supplementary order, was crafted was that it stated that when immigration officers detain foreigners, when considering their arrest and detention, they must consider whether the interests of justice permit the release. The court also ordered that detained foreigners must be brought before the court within 48 hours, and they must be released if it's in the interest of justice to do so. And then they must also be given an opportunity to make representations to court, both orally or in writing. Now, the manner in which this order was crafted was that it provides appropriate guidance to address the unconstitutionality that was identified in the judgments without affecting the separation of powers doctrine. And this the court did because the court recognizes that there is a range of possibilities that the legislature may adopt to cure any unconstitutionality which the court has identified. Another remark I'd like to make, Chair, is that Section 59 of the Constitution states that the NA must facilitate public involvement in the legislative and other processes of the Assembly and its committees. Now, in one of the leading Constitutional Court judgments that dealt with the issue of public involvement as enumerated in the Constitution, the court said that the process of public involvement is a process by which the public participates in something. Facilitation of public involvement in the legislative process therefore means taking steps to ensure that the public participates in the legislative process. And this the committee has done by calling for written submissions as well as holding public hearings. What the court has also stressed that for meaningful public participation, the persons concerned or the public concerned must be manifestly shown the respect due to them as concerned citizens, and legislatures must have the benefit of all inputs that will enable them to produce the best possible laws. The courts have also said that all parties interested in the legislation should feel that they have been given a real opportunity to have their say, that they are taken seriously as citizens, and that their views matter and will receive due consideration. at the moments when they could possibly influence decisions in a meaningful fashion. The next slide then refers to 3 other judgments where the courts have given meaning to what meaningful public involvement entails. I don't want to really hone in on this, but the point we are trying to make is that even though Parliament is not bound by what the public has to say, the Parliament is obliged to actually consider those views and give it due consideration. And if it feels that it is a valid comment or a valid point to be incorporated in the legislation, then Parliament may do so. Having said that, I'd just like to go and deal with the first issue where there was certain disagreement. This deals with the interest of justice criterion, where the public said that the phrase contained in the bill is too broad, can be applied subjectively, is inherently inflexible, and can be implied in various ways. The term also fails to provide the necessary guidance to ensure that the discretionary power that it grants to the immigration officer is exercised in a manner that aligns with the protections afforded in the Bill of Rights. Legislation must therefore provide clear guidelines to ensure that any limitations on the rights are justifiable. The public was also of the view that the criterion fails to provide the necessary guidance to officials who are meant to apply it, and hence clear and equitable criteria for this interest of justice assessment must be developed. Now, just to quickly recap on what the key findings were in the judgments regarding this issue. It must be noted that the Constitutional criticized the Section 34 of the Immigration Act for conferring wide discretionary powers on immigration officials without providing any further guidance. The court also said that the section offends against the rule of law by failing to guide immigration officers as to when they may arrest and detain foreigners before deporting them. In the 2023 judgment, the court introduced then the interest of justice standard, which the court said must be considered to determine whether the detention be discontinued. But interesting, this court also acknowledged that not every decision maker under Section 34(1) will be a judicial officer. For the immigration officer, an interest of justice test may well present interpretive challenges. Now, having said that, Chair, this slide deals with the views of our office, the department, and Oxley. At the outset, I must say that all of us, all 3 officers, we agree that factors or further guidance should be listed or provided to assist in immigration officers in particular in implementing this interest of justice criterion. However, where there is disagreement is in respect of which legal instrument or which document such guidance should be provided. Now, the department is of the opinion that such guidance should be provided in their internal departmental standard operating procedures. The Office of the Chief State Law Advisor is of the opinion that the committee should decide where this guidance should be provided, whether it be in the Act itself, whether it be in the regulations, or whether it be in the SOPs. Our office, we are of the opinion that such guidance must either be in the Act itself, meaning the primary legislation, or the Act should contain an express provision that such guidance must be provided by the minister in the regulations, meaning in subordinate legislation. And our support for this lies in the Dawood judgment. And our view is that the reason we would oppose it being in an SOP is because an SOP is an internal document and it's not readily available or accessible to the public. Now, having said that, Chair, what we would advise the committee is that in the event that the committee agrees that the factors or guidance should be set out in the Immigration Act, then the bill should be amended to include these factors, and that the department must then assist on what these should be given their expertise and experiences. Or in the event that the committee decides that the regulations must provide such guidance, this would then require that Section 7 of the Immigration be amended to obligate the minister to make the said regulations and to publish the regulations in the Gazette, and that Section 34(1)(a), as contained in the bill, be amended to provide that the immigration officer must take into account these prescribed factors when considering whether the interests of justice permit. However, we understand that this is also subject to deliberations and a decision from the committee. The next issue, Chair, deals with the Section 35(2) rights, where the public was of the opinion that the bill must state that the detainee must be informed of all the rights contained in Section 35 of the Constitution, and the bill should therefore reflect the wording of Section 35 with regard to access to legal representation. Public submissions submitted that legal representation in deportation matters is limited to those with financial means or the few that are assisted by the law clinics. They are of the view that persons arrested for deportation should have access to free or affordable legal representation. They stated that state-funded legal aid is generally absent in Section 34 matters, and requested that the legal aid manual must be amended to allow for legal representation of persons in civil proceedings. With regard to access to interpreters, the public stated that access to interpreters and to language services for detainees must be enhanced, and they must be explained their rights in a language that they understand, and that they must understand their rights and effectively participate in legal proceedings. The information given to them must be in a language that the foreigner understands, and they were of the view that the words "when possible, practicable, and available," which is contained in the bill, waters down this right to information in a language that the detainee understands, and are of the view that these words or this caveat should be deleted. Now, again, just quickly recapping on the key findings of the court judgments. In the 2017 judgment, the court stated that Section 34(1), or recognized that Section 34(1) does not require that a detainee be informed of the rights enumerated in Section 35, apart from being told of the reason for the detention. The court noted that Section 35(2) demands that a detainee be informed of his or her right to legal representation by a lawyer, and to be assigned one at state expense if substantial injustice would otherwise result. They also noted that the section does not require an automatic judicial review. It also did not allow the detainee to make any representations to the court, either orally or in person, nor did it permit the detainee to appear in person. Another flaw was that it allows the detention to continue for at least 48 hours before the detainee may be released in circumstances when the immigration officer fails to ask for confirmation. The court said that the Section 2 does not permit the detainee to make any representations to court. The courts say that the court, considering the application, is under no duty to offer the detainee a hearing, and that it denies the detainee the right to challenge the lawfulness of his or her detention in person. Now, it is noted that the bill does not contain a reference to all the rights referred to in Section 35(2) of the Constitution, nor does it contain all the findings of the 2017 judgment. Having said that, Chair, our office is of the view that in light of the findings, particularly at paragraph 51 of the 2017 judgment, the CLSO notes that the bill does not contain a reference to the rights highlighted by the Constitutional Court, in that it does not require the detainees to be informed of their Section 35(2)(a) to C rights, apart from being told of the decision to detain. As I said before, Section 35(2)(a) requires that a detainee be informed of the reason for being detained, requires that a detainee be informed of the right to choose and consult with a legal practitioner, and also be informed of the right to have a legal practitioner assigned by the state and at state expense if substantial injustice would otherwise result. So we note that the bill does not expressly provide for the detainee to be informed of these rights. The department, in their responses, stated that Clause 1B of the current bill does indeed provide for a detained person to be informed of his or her rights, as contemplated in Section 35 of the Constitution. The Office of the Chief State Law Advisor, in their response, stated, by referring to paragraph 42 of the 2017 judgment, they referred to where the court stated that Section 35 applied to illegal foreigners detained in terms of Section 34, and therefore it is not necessary to restate the provisions in the bill. Chair, our office does not agree with the department that Clause 1B of the bill provides that a detained person must be informed of his or her rights, as per the court's finding, in that Clause 1B of the current bill only provides that the detained foreigner be informed of the decision to deport him or her and the right to appeal this decision. It does not expressly provide that the detainee be informed of the reason for the detention, the right to legal representation, and the right to state-funded legal representation if a substantial injustice would otherwise result. Chair, we are also of the view that that one of the findings in the 2017 judgment is that the court noted this flaw in Section 34.1 by saying that Section 34.1 does not require that a detainee be informed of his rights in Section 35.2. And then the court said that it will be recalled that Section 35.2 of the Constitution also demands that a detainee be informed of his or her right to own legal representation or state-funded legal representation. With regard to the issue of information to be provided in a language that the person understands, we wish to point this committee's attention to Section 35.4 of the Constitution, which provides that whenever this section requires information to be given to a person, that information must be given in a language that the person understands. Now, the bill includes the caveat that the person be given this information in a language that he or she understands, where possible, practical, and available. And the submissions that receives indicate that these words must be deleted as it limits the right contained in Section 35.4. Now, we acknowledge that Section 36 of the Constitution does allow for the limitation of rights, provided the limitation is reasonable and justifiable. Now, in the response, the department indicated that deleting these words, meaning deleting the words where possible, practical, and available, will have huge financial implications. The Office of the Chief State Law Advisor submits that the words, when possible, practical, and available, already formed part of the Act, and it's not a new amendment in the bill, and has not been challenged to date, and that when interpreting those words, the ordinary meaning of the word should be used. Now, we would just like to state, Chairperson, that it must be noted that the Constitutional Court has expressed that costs alone cannot be a justification for any limitation of a right. Also, while it is noted that the words are currently in the Act and that there were not a new amendment in the bill, the entire bill was published for comment, and the comments received should be considered by the committee. With regard to the access to legal representation and state-funded legal aid, the department has confirmed that detained persons are allowed to consult with their legal representatives. State-funded legal representation is catered for in the Legal Aid South African manual and is assigned or should be assigned in instances where substantial injustice would result. The department also indicated that courts often adjourn proceedings in matters where a state-funded legal representative is requested. Chair, on this issue, we say that the department is best placed to attest to what the situation is on the ground in respect of state-funded legal representation in terms of Section 34 detentions. Having said that, Chair, our recommendations to this committee is that, given the findings of the Constitutional Court, the bill should be amended to include that the detainee be informed of the rights, specifically those listed in Section 35.2a, B, and C, which is the right to be informed of the reason for being detained, to be informed of the right to choose and consult with a legal practitioner, and to be informed of the right to have a legal practitioner assigned by the state and at state expense, because this was a particular flaw identified by the court in respect of Section 34. As said before, the department is best placed to attest to the situation relating to detainees' access to legal representation and state-funded legal representation. In line with the 2017 judgment, we recommend that the bill should provide that representations may be made orally or in writing. And then as far as the caveat that is contained in the bill, which is also currently in the Act, namely referring to the words when possible, practical and available, we recommend that the department provide this committee with reasons to justify why those words should not be removed. In other words, the department must show that the limitation is reasonable and justifiable and complies with Section 36 of the Constitution. The next issue, Chair, refers to the issue of children, where a lot of submissions received indicated that child migrants who lack proper documentation are automatically considered as illegal foreigners and are arrested and detained in facilities that are not appropriate for children. Submissions entail that unaccompanied minors should not be arrested but be placed in a shelter, and the child must be dealt with as a child in need of care under the Children's Act. Submissions were also that detention of children should only be as a measure of last resort and for the shortest possible appropriate time, and that the bill, unlike the Refugees Act, does not contain any provisions for unaccompanied migrant children and how they should be dealt with, and that the department should take on a child-centered approach when dealing with irregular migrant children and their rights, as in Section 28 of the Constitution, should be protected. Now, our response to this committee previously was that Section 28 of the Constitution provides special protections for children. That protection is afforded to every child, not just a South African child. The Section 28 also defines a child as a person under the age of 18, and there are various rights listed in Section 28 which are contained in this particular paragraph. Of note is the fact that it expressly states that children must not be detained except as a measure of last resort and only for the shortest appropriate period of time, and children must be kept separately from detained adults and treated in a manner and kept in conditions that take account of the child's age. We also presented to this committee that currently the Immigration Act includes the term child in various sections, but does not define the term child. It also uses the word minor. And in one section of the Act, a child is also referred to as a child under the age of 21. The Act does not expressly state how unaccompanied migrant children should be managed and dealt with, nor does it expressly provide that the detention of children be a measure of last resort and that children be detained for the shortest appropriate period of time. Now, in the responses, the department responded that the internal departmental SOPs duly guide immigration officers on the processes to be followed when children are involved. They indicated that children are not detained but placed in places of safety through the Department of Social Development. They also suggested that the amendments from the public are not in line with the current Constitutional Court judgments that the bill seeks to address, and that any further amendments should be considered during and form part of the supplementary work that is being done on the white paper on immigration. The Office of the Chief State Law Advisor was of the view that Section 28 of the Constitution, the Children's Act, and also the Child Justice Act provide sufficient protection for children, and they also refer to Section 34(1)(e) of the Immigration Act, which states that foreigners concerned shall be detained in compliance with the minimum prescribed standards, protecting his or her dignity, and therefore they submitted that the Act and the legislative framework relating to children offer sufficient protection for children. Now, In our response as chairperson, we agree that the issue relating to children was not a finding and it was not addressed in the Constitutional Court judgments that are under discussion. They were issues that were brought up by the public. Our concern, however, is that Section 34 of the Immigration Act can be interpreted to mean that children can be arrested and detained. The reasons being is that the section does not exclude children. Illegal foreigner is defined as a foreigner who is in the country in contravention of the Act, and foreigner means an individual who is not a citizen. These definitions can therefore include a child. Our office did not have access to the department's standard operating procedures, and therefore we cannot comment on whether they adequately protect children. I know this committee has also requested those SOPs and might have now received them, but our office has not seen them. The current regulations deal with facilities where detainees are kept. It does not expressly indicate that children should only be detained as a measure of last resort and for the shortest appropriate period of time. However, again, the department needs to confirm this if it does. And we are of the view that the Child Justice Act does not apply in these instances to administrative detention, because the Child Justice Act deals with children in conflict with the law and the criminal justice system, but does not deal with the civil detention referred to in the Immigration Act. Hence, Chair, we also feel that the amendment bill should therefore, similarly to the Refugees Act, expressly provide for how unaccompanied migrant children should be managed, and that they should be treated as children in need of care, and that the bill should, similarly to the Refugees Act, expressly provide that the detention of the child must only be used as a measure of last resort, and that children be detained for the shortest appropriate period of time, separately from adults. The next few slides then just summarizes the recommendations that we've already alluded to. Firstly, that the bill include a definition for child to provide certainty, that the department clears up the issue of whether minor intends to mean child, and then the act be amended or cleaned up accordingly. Like I've said before, that the bill, similarly to the Refugees Act, provide for how unaccompanied migrant children should be managed. What we have there in blue, Chairperson, is the current wording that's contained in the Refugees Act when it deals with how children should be dealt with. Obviously, should a provision like this be included in the immigration bill, we'll have to amend it accordingly. And we also say that the bill, similar to the Refugees Act, expressly provide that the detention of the child must be used as a measure of last resort and for the shortest appropriate of time. Again, in the blue, we put an example of what's currently contained in the current Refugees Act. We just thought we'd also include this particular slide on the CC deadline, as it appeared to be that some members as well as stakeholders are of the view that there is a court deadline that needs to be met with this bill. Chair, we want to say once again that there is no current court deadline that should be met. The initial deadline that was set by the court judgment in 2017 lapsed in June 2019. Also, the date provided by the court in the 2023 judgment by which the legislation should have been amended has also passed on 29th October. Both judgments, Chairperson, provided a remedy that would apply after the orders had lapsed and that the deadline had passed, which is currently therefore in operation until the bill is passed. There is therefore no urgency or deadline by which this bill needs to be passed. And that concludes our presentation. Thank you, Chairperson.
Chairperson? Hi, Chair. You are muted.
Yeah, I was muted, Mr. Matonsi. Thanks very much, Daksha. Can we then get the Chief State Law Advisor?
Good morning, Honorable Chairperson and Honorable Members. It's Sarah Govender from the Office of the Chief State Law Advisor. Chairperson, Honorable Members, the Office of the Chief State Law Advisor remains of the opinion that which was submitted on the 14th of March 2025, which has been circulated, and should it be required to be shared, Mr. Mthatha has undertaken to share it. Chairperson, all the submissions of the Office of the Chief State Law Advisor has been presented by Parliamentary Legal Services in their presentation. So if we could just summarize in one line in respect of the 4 issues. Chairperson, with respect to interest of justice criterion, we did accept that guidance needs to be provided to immigration officers, and the department has undertaken to provide this guidance. And in respect of the instrument which they will provide this guidance, they will be able to provide the committee with further information in that regard. With regard to the Section 35(2) rights, our understanding is that the wording of Section 35(2) specifically starts with the word everyone, and that would include illegal foreigners, foreigners in the country, or foreigners who are being subject to this particular section. And it's therefore there's no lacuna or gap in the law, as there is cover for them in the Constitution. The third factor is with regard to the children and protection of children. The Children's Act, we are of the legal opinion, having examined the Act, that there is sufficient protection for children or immigrant children or foreign children in the Children's Act. And lastly, with regard to the wording of Section 34(1)(c), when possible, practicable, and available, we have indicated in our submission that this wording is sufficient. It has not been challenged in court, and it therefore appears that there is no need to amend it. With that being said, Chairperson, the bill in its current form appears to be constitutionally sound. We have noted the presentation that has been made, and in this regard, we do accept that should the Honourable Committee wish to amend the bill in any respect, it is within the domain and powers of the Honourable Committee, and we will leave this in the hands of the Honourable Committee, and we will be available to assist the committee in this regard. Thank you, Chairperson.
Thank you very much, Ms. Govender. DG, I'm not sure how we're going to run on your part. Is the DG in the meeting, Mr. Mthatha?
No, I didn't see him, Chair, but Advocate Malakat is in the meeting.
Okay, thanks very much, Advocate Malakat.
Good morning, Chair, and good morning, members of the committee, as well as colleagues on the platform and other colleagues. I think, Chair, the Office of the Chief State Law Advisor has indicated the same position that the department also has. Just to add that on the interest of justice, if the committee is of the view that the bill should empower the Minister of Home Affairs to make regulations in order to deal with the interest of justice criterion. As the Parliamentary Legal Services has indicated that we may need to look at Section 7 of the Immigration Act. We only just wish to indicate that there may be no need to amend the Section 7 because Section 7(1)(a) already empowers the Minister of Home Affairs to make regulations relating to the powers and duties of immigration officers. So if there is a need to do that, we can do that in terms of that provision. On other matters, I think we are aligned to what the Office of the Chief State Law Advisor has indicated, that when it comes to children, there is sufficient protection and there is no need for us to amend the legislation. That we also of the view that we need to restrict this bill to what the Constitutional Court has indicated. And if there is any need, of course, or if the Portfolio Committee also then decide to amend the legislation, we are also available to assist the portfolio committee in this regard. But we think the bill as it is sufficiently deals with what we have been enjoined to do in terms of the Constitutional Court order. Thank you.
Thank you very much, Advocate Malekate. Members, these are the two issues that are reflecting in the report. I will, and I think there will be a process to deal with clause by clause. It may not be today. Once we've noted Reverend Mission, once we've sought clarity, we'll then schedule also for deliberations on a clause by clause. Can I invite members to comment on the issues that have been raised or the report that have been presented by our stakeholders?
Mr. Ross, hand is up, Chair.
Thank you. Honorable Ross.
Thank you, Chair, and thank you to all the presenters. I think this was a tremendously valuable exercise to assist us. Chair, once again, I think in the last meeting on this topic, we looked at the underlying principle that we deal with the requirements of the judgment and save other kinds of inputs and issues for the immigration law review process, which is underway at the moment. I'm not sure that we did receive the standard operating procedures. I don't remember that, but I am comforted to hear that the department is working on inputs in terms of the interest of justice criteria. The only question that I just have for the two sets of legal advisors is, if we say that these should be regulated, how are we then assured and comforted as a committee that all of the issues that have been raised will indeed be encoded in those regulations? Then certainly it makes sense that the detainees be informed of their rights, but certainly where practical, Section 63A of the Constitution, it even talks about our official languages. So it says the national government and provincial governments may use any particular official languages for the purposes of government, taking into account usage, practicality, expense, regional circumstances, and the balance of the needs and preferences of the population as a whole. So I just also would like to get further guidance. This provision talks about official languages, and already with these languages, which are quite commonly known and understood, there's already provisions in the Constitution that are talking about practicality, expense, regional circumstances, etc. So if I could just get some clarity in terms of your view on the Section 63A in particular. Thank you, Chair.
Chairperson, there's Ms. Ngobeni and Mr. Ngubane.
Thanks very much, Ms. Ngubeni, Honorable Ngobeni and Honorable Ngubane. Honorable Ngobeni, you can proceed.
Thank you, Chairperson. Good morning, colleagues. I want to welcome the presentation, and I also want to commend the work done, particularly when it affects the undocumented minors, particularly those who, as you have seen in recent weeks and months, we've had a lot of children, whether abducted or trafficked into the country, who are at the risk of being stateless children. Mine are two questions of clarity. I do want to support and maybe to have them reiterate in terms of the powers of the minister to codify. I think codifying is better than SOP, and I do agree that SOPs can be cumbersome to implement. And I think dealing with the issues that are so grave about immigration in our country, it's definitely important that we have things down in black and white so that everybody can follow, and if those who don't follow can be dealt with accordingly. I just want to get a sense in terms of the idea of children of undocumented minors or children who are brought into the country by themselves without any type of legal guardian. In other words, the ones who are trafficked. What happens to those children? What shelters do they go to? And then are there pathways for them to be either repatriated to their own countries where they can be reunited with their families, or what do we do with them? Because it's not clear as to whether there is a pathway for them to have, even if it's temporary citizenship, because the reality is that they do reside in the country, they do roam the streets, or they do get to be in a shelter. They do have the right to receive education like every other child in this country. But I think it's naive to think that we have these regulations that kind of offer them protections, but protections that aren't really guaranteed. And I have not seen any quantification of what that looks like for these young people. And then the interest of justice criteria, I mean, I'm open to, in fact, I think it's good that there is a move for us to deliberate on these issues a little bit further. I think we should do that, given that you've seen the wave of questioning of ministerial powers of late. And so, I don't think our committee should be subjected to that, because the issue of immigration and illegal immigration in particular is a grave one in our country. And then finally, I just need clarity on the issue of language, because as far as it's practical, even to provide support and education in South Africa for citizens in this country, how is it that we then can say, or we can accept that detainees or undocumented people must be communicated with in their own language, irrespective of cost? I don't know if that is language that we would condone. I just want to get clarity on that, because for me that's not only impractical, it's irrational to suppose that the number of people who come into South Africa from all over the place and the languages that they speak must just be provided for. How do we do that? Do we do that in person? Do we do that? Do we get people coming from their own embassies? How is that managed as well as financed? If it comes from their embassies or their places of representation in South Africa, whether they have missions here or not, who foots that bill when that time comes for their issue to be deliberated upon? I would just like to get clarity on those four things. Thank you.
Thank you very much, Honorable Ngubane.
Thank you very much, Chair, and good morning, colleagues. And Chair, I think from my side, we appreciate the presentation by the Parliamentary Legal Services and Chief State Law Advisor. The major highlight, Chair, that comes out of this two presentation from my side, I would like to note, Chair, that somewhere, somehow, as a country, we need to cure the real disease. We seems to be misdiagnosing the disease of this immigration amendment bill we're trying to fix. For the mere fact, Chair, that someone comes into the country illegally and all of a sudden, South Africans and South Africa and all its taxpayers must now burden themselves with their resources that are already stretched, and then with their tax money now start to take care of illegal immigrants. That, Chair, is a concern from our side. So somewhere, somehow, Chair, we need to really look at the real illness of this country, the real source of illness of this country, Chair. Though I see we're good at what we're doing, we seem to be expert in what to do, how to run around fixing immigration bill, marriage bill, nitty-gritty, Children's Act, human rights, and all those stuff. But at the end of it, Chair, the real symptoms of this sickness of this country that we are all busy discussing now, it's all underline or lie in our constitutions. Again, I'm highlighting, Chair, it's so unfair that us as South African and all South Africans, that we're sitting in this country, we are honorably paying our tax money, working our ass off, making sure that country live up to expectation for our children, but all of a sudden, all of us as South Africans and our already stretched resources, unemployment rate is high. Well, we must now be burdened by people who comes into this country illegally that must now be treated like this country is a nanny state. That, Chair, is my major concern on this. Again, Chair, I'm highlighting somewhere, somehow in our senses of these countries, the sense must kick in. We are now expert in all things that are really not the sickness of this country. The sickness of this country is the Constitution, Chair. Thank you very much.
Thank you very much, Honorable Ngubane. Honorable Maji.
There's a hand from Honorable Mthatha.
Mthatha. Honorable Mthatha. Proceed.
Thank you very much, Chair. I must just also state that we welcome the presentation, and I would just like to highlight something on the presentation, Chair, on slide number 6, where it states that immigration officials, when considering arrest and detention, to consider whether interest of justice permit release. And you would have noted, Chair, that on all of the oversights that we've done, the issues raised by the immigration officers, as to say they detain and they go through hours of work, investigations and all of that, only for the immigrant to be released in court. So that does not make sense for them, Chair. It's like they're doing all of this work for nothing. And again, where it emphasized that guidance needed to be provided for these immigration officers when they do this detaining of illegal immigrants, that it should be emphasized within the Act, even if there would be SOPs within their departments. But through the Act, it must be able to guide them, because if they who are supposed to do the work does not, and they are not guided properly, they are not empowered properly, then we as citizens looking at this crisis that we're having as a country, I would really like for it to be emphasized, the Chair, and as well as the rights to representation. It stated the cost cannot be a limitation. Chair, we are saying the department, border management agencies are saying they don't have the necessary human resource. They don't have the funds to be able to control our borders. So now we are going to spend money again. We spend money that's so overstretched again on all of these things, which was also mentioned of the language, that they need a presentation in their own language. Where is the cost of all of this money is going to come forward, Chair? So that's what I want to deposit, Chair, that we really empower the immigration officers. Thank you.
Thank you, Honorable Mthatha. Honorable Mohale.
Thank you very much, Chairperson. Mine is very short. It's just to deal with the role of the legal aid. I just want clarity, Chairperson, as to when does the legal aid get involved? When do these undocumented people have the right to get representation from legal aid specifically? Because here in the presentation, it says it's only in instances where substantial injustice would result. So I just need clarity in that regard as to, in the absence of that substantial injustice, does it mean therefore that the legal aid or the undocumented persons don't have access to legal aid? Thank you, Chair.
Thank you very much, honorable members, for your inputs. I will invite Advocate Malikat first to deal with these 4 issues that Honorable Ross has raised, and then Honorable Ngobeni, Honorable Matopa, and Honorable Mukhale. And then I will invite the Chief State Law Advisor if they want to comment in the Parliamentary Legal Services. I think most of the issues is Mr. Advocate Mukhale, Advocate Malikat, that need to comment in relation to the bill. Advocate Malikat.
Thank you, Chair. I think what honorable members of the committee have commented on, and as far as it relates to reading the rights to foreigners in the language that they understand. Those are the same issues that we had buttressed our argument that it may be very impractical to then indicate that South Africa must provide interpretation of all, and this maybe I may even be exaggerating that for the entire world, that South Africa must be able to provide interpretation for all the languages that are there in the world. And I think Honorable Ross then comes back and say, when you look at Section 6 of the Constitution and other provisions of the Constitution, the Constitution does enjoin the state to ensure that first we deal with the Bill of Rights in a manner that it does not cost the state too much. And we also, you recall, Chair, that we made an example that even in our court system, the Department of Justice is struggling with this issue in terms of providing interpretation. And again, we saying it may be very impractical for the department to be able to do so. But what we do have, and I have the acting DDG for immigration services on the platform. But what we do have is that where there is where we are able to provide such interpretation, the department is able to tap into what we currently have within the refugee asylum seeker management system, where we have interpreters that are available, and we then provide such interpretation. The other issue is we have indicated that if the portfolio committee does indicate to us that perhaps the standard operating procedures are not best suited to provide the guidance to immigration officers as far as it relates to the interest of justice criteria, that there is, if we look at Section 7, 1A of the Immigration Act as it is, it empowers the Minister of Home Affairs to make regulations relating to the powers and duties of immigration officers. Perhaps we can look at that and deal with it. And I think what the Honorable Ross then is to say, how then do we ensure that the minister or how do we ensure that the minister indeed does what we have requested from the portfolio committee side to do? And I think if there is a need, we should be able to then, once we have come up with the regulations, provide the regulations to the portfolio committee for the portfolio committee to scrutinize same and to ensure that we have properly dealt with the interest of or criterion interest of justice criterion to ensure that we provide the necessary guidance to our immigration officers. I think when it comes to children, what Honorable Ngobeni raises, I think the practicalities of it, the acting DDG would assist me in providing the practicalities of it. But what I know and what happens within the department is that when we come into contact with children, such children, we then have a transfer mechanism to the Department of Social Development, and Social Development in terms of the Children's Act is then enjoined to ensure that if there is any family reunification that they need to do, they will follow the process and make contact with the country where the child is coming from. But there are systems in place from the DSD side in order to ensure that such a child, if there is family reunification, is reunited with his family. If there is anything that needs to be done other than family reunification, there are processes that the Children's Act then regulates or enjoins what needs to happen to those. I think the other person or issues that are raised from Honorable Gobani, I think it's on point. Is again similar to what Honorable Ross had then indicated as it relates to who then foots the bill. I think the other issue, Chair, that I think the acting DDG can then deal with the practicalities of it. But in terms of the Legal Aid Board, they have their own processes and that they need to follow, and in order to then make a determination as to whether or not legal representation would be provided to any individual, be it a South African citizen or non-South African citizen, at a cost to the state. And I think if there is a need for this portfolio committee to then understand how they get to representing any person, maybe the portfolio committee may consider calling upon the Legal Aid Board to come and provide representation on how they deal and with those issues and provide legal representation. I think also acting DDG for immigration services can also deal with the practicalities of how we ensure that we comply with the rights as contained in Section 35, as far as it relates to legal representation and access to same within our space. I think I may have dealt with all the issues, Chair. Thank you.
Thank you, Advocate Malikat. Acting DDG, is there any other matter you want to raise?
Thank you very much, Honorable Chairperson, and good morning, honorable members. Just one thing, Honorable Chair, there was a matter on cost, on deportations, for example. South African government pays for the full cost of deportees. There's no country that pays even half of the cost for deporting their nationals. It's the full cost is borne by the taxpayers of South Africa. Then, Chair, in terms of, I just want to confirm what Advocate Malakati said. We do not arrest children. We always involve the Department of Social Services, Social Development in that regard. In terms of interpreters, as Advocate indicated, that we would engage with our refugee center, but also the interpreters in the courts, in the magistrates' courts. Many times, Chair, that we find that when we do interrogate or interview a suspected illegal foreigner, they speak English very well, but when they appear in front of the magistrates, that's when they claim that they did not understand, and then an interpreter needs to come on board, which means that the case is then postponed for that matter. So certainly the interpreting services is going to pose a challenge for us, but it's something that we will have to make sure that we we meet and we do afford that right to any person that we interview. Chair, in terms of the Legal Aid Board, let me not speak on their behalf, but what normally happens is once we apprehend a particular person and they get to a police cell, they would then ask for their own representation, or they would approach the magistrate or the prosecutor to assist them in that regard as well, Chair. Let me stop there. Thank you very much, Chair.
Thank you very much, Acting DDG. Ms. Govender, is there any other matter I want to comment on?
Thank you, Chairperson. Chairperson, I think I have been covered by Acting DDG and Advocate Malekate. Just with regard to Honorable Ngobeni, I know she specifically referred to unaccompanied migrant children. And the Children's Act in Section 150 specifically provides for a child in need of care and protection. Section 151J lists an unaccompanied migrant child from another country as one of those children falling within the category of a child that needs care and protection. And then the rest of the Act provides in detail how such a child will be handled. And as Advocate Malekate just spoke about, whether they need to be reunited with their family, reunification. So I just specifically want to mention that because I know she asked specifically for migrant children. So I think that Section 150 of the Children's Act does cover that. Chairperson, I think I've been covered in respect of the other questions. Unless there is anything else remaining, I will be available to assist to answer that.
Thank you very much. Parliamentary Legal Services, is there any other matter?
Yes, Chairperson. This is Daksha. I just want to address the question posed by Dr. Roos on how we can ensure that the minister actually makes regulations to provide the guidance if that is the way the committee decides. Now, Advocate Malekate referred the committee to Section 7 of the Act, and he stated that Section 7 would allow for that. But I just want to alert the committee that currently Section 7 reads, the minister may, after consultation with the board, make regulations. Now, the word may doesn't place an obligation on the minister. It's a discretion that the minister may do it, but he's not obliged to do it. So for our view is that in order to ensure that the minister actually does provide this guidance in the regulations, we would need to amend that section to read that the minister must make the regulations to provide guidance to the immigration officers. Chair, I'm going to hand over to my colleague Clara, who's going to address the questions related to the language issue.
Good morning, Chair and honourable members. Thank you so much for this opportunity. With regard to Section 6 of the Constitution, which deals with languages, Section 6.3 deals with the official languages, and it deals with the obligation on national government and the provincial governments to use official languages, and then sets out what the factors are that the national government and the provincial governments must take into account in deciding on which official languages they would use. So that is why it states that they need to take into account the usage, practicality, expense, regional circumstances, and the balance of the needs and preferences of the population as a whole. That's now for the national government, or in the province concerned for the provincial governments. So those governments must all use at least 2 official languages, and those factors must be taken into account when they decide which official languages they will use in communicating with the public. So that is what Section 6.3 deals with. Now, Section 35.2 of the Constitution says that everyone who is detained must be informed of some of the rights that are set out in Section 35.2 in a language that the person understands. It does not stipulate that this must be in the mother tongue language or in that person's own language. We also are of the view that in terms of Section 36, this right can be limited, but that the department will have to justify that limitation. And as Daksha has indicated, the courts have said that costs alone cannot be a justification for a limitation of a right in the Bill of Rights. So the department will have to advise the committee what the situation is on the ground. We are simply responding to the public submissions, and the public indicated that this is an issue that they are concerned with. And then also with regards to possible other options, the department in the past has indicated that they can perhaps consider other options, for instance, by providing information on these rights in printed form in different languages that can then be given to the detainees. So it's our view that they should consider all these other options. And just lastly, also to note that Section 35(2) doesn't specify that this should be by way of an interpreter. So other options can also be considered. Thank you, Chair.
Thank you very much, Daksha and your team. Honorable Ngubeni, I see your hand. Or is it a legacy hand?
Sorry, Chair, I just couldn't find my unmute button. I fully appreciate the response with regards to Section 150 of the Children's Act. The question of clarity that I was asking relates to the realities that are happening to these children who may not have the opportunity or the ability to be sent home and be reunited with their children. This is reality. This is not what is legal and what is right. The question I was asking is, are there pathways? Is there a pathway to documentation for these children? Because they do exist. They do get lost in the ether. They are at the mercy of South Africans who are at loggerheads trying to get them documented. I can give you reams and reams of cases that are sitting on my particular desk of children such as these, where parents or grandparents or left parents or parents who have passed away, who were in the country illegally, but these children are lost in the ether. Social development or no social development, they do not have a clear pathway to some kind of documentation, whether that documentation is temporary or not. And so I fully appreciate what we are saying in this meeting, but I want to get clarity from the officials as to such cases. How are these cases dealt with? When we receive such complaints or such requests for assistance and help, it's not enough to say they must be sent to social development. The reality is that there is no documentation. I want to hear a definitive answer with regards to their pathway to documentation, particularly in cases where there can be a record of proof that their parents no longer exist. They only have grown up in South Africa. They do not have links to wherever it is that they may have come from. So I'm referring, and I referred specifically also to these children who are being abducted from their countries and are brought here. We have them. You're talking about the kids that are coming from Ethiopia and everywhere else. I'm sitting with cases now of kids from Lesotho, from Zimbabwe, who are in this situation. So I would like a definitive answer in this regard, please. Thank you.
Acting TTG.
Thank you, Chair. In such cases, Chairperson, Honourable Member, the Department of Home Affairs will work closely with the social developers, with the social workers, because the most important part then is the identification of the minor child. So the social workers will do a full interview to determine information from the child. Once they would establish from which country the child is from, they would then engage the embassies of those countries. They'll try and determine the identity of that particular child through a full investigation from social services. And then they will approach the Department of Home Affairs. So when it gets to a stage where the child then needs to be reunited with their family in some other country, their foreign missions will assist them with providing documentation, and the Department of Home Affairs will work with the social services for the repatriation or deportation of that child back home. But it would be a cooperation led by the social services with the embassies of that particular child and with the Department of Home Affairs. Will work together collectively to deal with the identity and reuniting the child with their family members. Thank you, Chair.
Thanks very much, honorable members and the team, stakeholders, for your responses to this question that we're dealing with. Two issues which I'll propose, members, and I think the content advisor will assist us with the research unit to facilitate clarity around the legal aid board in relation to representation. They may need to facilitate that detail and then bring the report to the committee in the next portfolio committee meeting, including the last subject, that issue that Honorable Ngobeni has raised and the acting DDG in relation to the collaboration between Home Affairs and social development, particularly on the process that is undertaken to make sure that these children are safeguarded. So I'll propose, members, that these two items in particular, or two issues, will task our content advisor to solicit with the Social Development and Legal Aid Board, and I think with the assistance of the Parliamentary Legal Services, so that in the next session, which I'll also propose that this item, we may need to consider it in the next meeting, so that all issues that have been raised are already clarified, and that will assist us to proceed with the process to deliberate or engage on the clause by clause of the Chief State Advisor to identify areas of amendment on the bill. Thirdly, is the issue that there are differences that has already been presented before the committee, and members may need to further consider these issues, but noting that there's an appreciation of work that has been done by all the three stakeholders, but also the comfort zone is that this bill, it also in line with what the court has directed Parliament to amend, and that should be the focus area of the portfolio committee. We'll then, noting all the issues that had been raised, note these issues that had been presented, and in the next meeting, Mr. Matonji, and I'll propose that we schedule it in Tuesday, so that we proceed with the decisions that may need to assist us to invite the Chief State Law Advisor to start the process of the clause by clause. Will that be sufficient, members, so that we step off this item?
That's supported, Chair.
Supported.
Supported.
Mr. Matonzi and the content advisor, are we on the same?
Yes. Yeah, we're on the same page, but I just want clarity. So the issue of the list of amendments, it will be taken, the decision will be taken next week after the report on the legal aid and the issue of the children, the social development.
Yeah.
So in other words, yeah. Okay. Thanks.
Yeah. I think it will be assisting so that when members take decisions on this matter, all the issues that have been raised were satisfied to proceed and able to accountable to the decisions that were being taken. Remember also this meeting will also have to have clarity on the process itself, but also when we deliberate for a decision, at least members are empowered on some of the issues that could not come through to this committee meeting. And I think Parliamentary Legal Services will also assist in that for the facilitation of that process. Will that be sufficient, Daksha?
Yes, Chairperson, we'll work closely with the content advisor and the committee secretary.
Okay. Thanks, members. We'll then step off this item. The next item.
Thank you, Chair. That's one from me. The chairperson has asked us to consolidate the issues and the debates around the budget and APP of the Department of Home Affairs and BMA. So these are the issues that were raised. Obviously, this is also in relation to the interim budget, and so some of the issues might change, but overall, given that we're not dealing with specific budget numbers, these issues should remain the same in our final budget report. So these are the issues that we got from the last minutes, and that will potentially be included in the budget vote report of the department when we, or the budget vote for Home Affairs and entities when we complete it. So the first issue they raised was that the committee was concerned about the moving the target of the amended white paper on citizenship, immigration, and refugee protection to a complete overhaul of vital statistics in South Africa, and how the supplementary amendment, how long the supplementary amendments will take. And the committee recommended that the target be moved to 2027. Secondly, the committee indicated that the infrastructure of the DHA on the ground, especially in rural areas, was deplorable. The committee needs to conduct an oversight into the department's legal unit because of its lack of capacity and challenges. The committee was concerned about the cost of deportation of undocumented foreign nationals and whether there was a better method for dealing with illegal immigration. The committee was also concerned about undocumented foreign nationals who are already in the country. The committee expressed concern about the DHA's renting of offices, which has cost implications. The DHA must engage the Department of Public Works and infrastructure regarding the post office buildings that are not used to convert them into offices. The committee raised concern about the 205 million rand irregular expenditure that is related to digitization, where the 350 more million records are being digitized. And does the department have a plan to implement the recommendations of the AG and whether consequence management has taken place? The department should fill vacancies within the immigration service and other branches. And the vacancy of the chief information officer and DG of immigration services, a DDG for immigration services, has remained unfilled. The DHA need to include a target for filling vacancies to capacitate itself. The committee wanted to establish a short-term plan to improve the stability of the National Population Register and whether it was possible to tap into the SARS network. There was also a recommendation that with the high volume offices or big offices, consideration should be made for the dual links to ensure that these offices do not face downtime. And the committee raised concerns on the challenges faced by the DHA when it comes to the payment of supplies within 30 days, and therefore DHA needs to furnish the committee with its plan to resolve such. Self-service kits were launched in May 2024. What is the implementation to roll out the program? The recommendation that were made by the CSI should be turned into project proposals and funded to address the downtime at DHA offices. And the number of modernized offices in all provinces should be increased, especially in rural areas. The self-service kiosk project is good, and there's need for security to ensure that they are not vandalized. So these are the, and then carry on the next page. In anticipation of the deficit from the monies to be received from the transfer, BMA applied to the National Treasury for an allocation of 2.9 billion in 2024 and was only approved an allocation of 250 million. This approved allocation of 250 billion is less than 10% of the requested allocation. In business case, the BMA requested over 4 billion for the National Treasury, but it was only allocated 1.753 billion. What are the critical issues that were not yet funded? The committee recommends that the skills must be readily available at each port of entry to inspect the consignments. The committee was of the view that the BMA baseline targets did not have details on whether these targets were achieved and how they would be achieved. The strategic and annual plan lacked detailed information on how they arrived at these new targets, and the DHA should provide narratives on how it will achieve the targets. The committee recommended that the BMA rework the targets following SMART principles. And then lastly, the BMA staff transferred from the different departments. How far has important vetting of these officials been completed? these are the main issues that we picked up from the members' contributions during the last budget debate. It also included the other issues of the CSIR and network issues in that same meeting. So it's not only budget issues. Thank you, Chair. This is, I believe, what you asked us to do.
Members, we are going to send, I think we'll enrich the issues that have been raised. We're just highlighting the issues that you may need to add. In the last strategic, in the last meeting, as the strategic plan was presented by BMA and Home Affairs, there were issues that members raised, and that it will be good that are reflected in the strategic plan moving forward. And want to send some of these issues to them. At the time they're coming back to the committee, they will be captured in the strategic plan or be considered with emphasis in relation to the budget allocation and the time frame or plans that must be reflected in this strategic plan. So if there's any other matter that we did not capture, members can note it, raise it, that we submitted to Department DDG, Acting DDG Yusuf, that is in the meeting. You will also note this matter. We don't need them to respond to anything now. We'll send to the department when they come back for the strategic plan review to be presented. I think some of these issues will be taken. One of the key issues that we have emphasized is on the white paper review. There was a target date that was identified to 2030. There was strong proposal from all of us as a committee that we may need to consider to review to 2027. And that must be occasioned by a plan towards approving the supplementary issues that may occasioned by the white paper, the plan, a process that must undergo to a cabinet subcommittee and the approval of a committee, and when is the bills going to be developed, to be tabled before Parliament, because Parliament, both the NCOP and National Assembly, still have to engage or conduct public hearing in relation to this white paper. Some of the issues that were raised in the previous item we may find expression in this white paper on the citizenship. So it's important that we input on this matter so that we don't adopt a strat plan when issues has been raised and members of the committee, issues that have been deliberating on in the previous 6 administration to date and have not been finding expression that will assist the citizen. The last point I think is of emphasis is on the CSRR recommendation and the plan to facilitate in relation to the budget allocation. Given the current challenges that Home Affairs is facing on the IT downtime and other related matters. The CIO, there's been an outstanding post that has not been filled, and the one that you're acting, DDG Yusuf, we have requested the department to also account to the this process, and when are they going to fill this position, and also the capacity of these 2 units in relation to the issues that have been confronted with. So those are some of the issues that we requested the department to come back to the committee. Any other addition? Honorable Mokhale, Honorable Ross, Honorable Mokhale.
Thank you, Chair. I think there was an issue of collection of fines that was highlighted, but it's not captured here. The collection of fines by the department. particularly for those bus companies and airlines which are bringing in undocumented persons into the country. Thank you.
Yeah, thanks. You'll add that matter, Honorable Ross.
Thank you, Chair. Chair, just on item 5, where it says the committee expressed concern about DHA's renting of offices, which has cost implications, and that the DHA must engage with the Department of Public Works regarding using post office buildings. Chair, the department indicated, I think it was in the last meeting, the strategy, that they are reviewing the footprint. So that footprint is where they look at all the offices combined and then come up with that. So perhaps we just need to consider that in the wording to say that we recommend that they consider these post office buildings when they look at this review of the footprint. But that's just a technical amendment. Thank you, Chair.
Okay, thank you. Honorable Ngobeni.
Thank you, Chair. I just want to add one thing. I think we've all witnessed the welcomed or perceived improvements in capturing of those crossing illegally, as well as trying to detain so-called facilitators. I just want to get a sense when they come back to us with regards to whether we are tracking the ability or the capacity for us to implement measures to deter attrition, particularly from those who are caught, because the plans do speak to performance targets, and I've not seen at the moment, and maybe it may just be my own oversight. I've not seen the performance targets in relation to what actually transpires on the ground. If they can be able to include that as well, it will be helpful to see whether or not we are performing as we intend to perform, and what else we can do to ensure that we enhance our ability to deter the illegal crossing as well as the illegal facilitation of these processes. But definitely the perceived improvements that we have seen so far is totally welcomed. So I just want to see how we can how they can or intend to strengthen that. Thanks.
Thank you. Any other matter? Okay. Thanks very much. DDG, you'll take note of that. We'll formally send correspondence for their attention, and Advocate Malekate on these issues. We'll have to rework the submissions with the views that are carried by members in this meeting. Let's step off this item. We'll now request to deal with the 2 reports. We've labored on these 2 reports, Lebombo Oversight Visit and Government Printing Works. If Mr. Matonsi or our content advisor can only deal with the recommendations, just to recap on the issues, and members will comments and will adopt these reports. Yeah, we've just gone through the reports. If you can just work on the recommendation, and they will add if there are other issues that we could not deal with.
Thank you, Chairperson. I'm on the recommendations of the Lebombo Oversight. The issues that we captured there in this report are that, having conducted the visit to the Lebombo Port of Entry, the committee recommends the following to the Minister of Home Affairs and the Commissioner of the BMA. Urgent discussion with the Minister are pleased to expedite the integration of SAPS members in all ports of entry into the BMA in terms of the BMA Act and provide full implementation protocol reports to the committee. A strong business case for the funding of the BMA to the National Treasury should be made. The BMA needs surveillance technology and additional border guards. The BMA and the Port Management Committee should engage with the Department of Health, especially during the festive season, to provide a mobile clinic and toilets along the N4 corridor where trucks queue to be processed into Mozambique during border closure. BMA should continue to proactively engage with their counterparts in Mozambique to assess the situation in that country. And the committee noted that drones at the Department of Land Reform and Rural Development is deployed to the 5 ports during the festive season, and the committee urged the BMA to procure its drones that would be used throughout the year to combat illegal migration and smuggling of goods across the borderline. The BMA should continue to engage farmers along the borderline to allow the BMA border guards and the SNDF members to be allowed ongoing access to private farms to patrol the borderline. This is what I have. Thank you, Chairperson.
Okay, members, is there another matter on the issues arising from the discussion of the oversight? And we've noted that there are some of the issues that already they've been on the plans, given the reports that we have received in our last portfolio committee during the budget and such plan presentations. Members?
Chairperson, Ms. Ngobeni sent this up.
Ngobeni?
Thank you, Mr. Matonzi. Chair, you know, when we were at Lebombo, I think we were, all of us, very clear with regards to the vandalized, literally non-existent fence. Of course, there's barbed wire, etc., and you could definitely see that there were different posts in terms of the boots on the ground, SANDF, and of course, when we were being shown or have a demonstration around the drones and how effective they would be. And I think we've seen over the last couple of holidays that that's definitely a welcomed development. I want to make a move to say perhaps if the minister and the department at our next meeting really just respond to the reinstatement of that electric fence. The infrastructure is there. There are many issues with regards to the reinstatement of the electric fence, purely on the side of humanitarian issues and whether or not we can manage it effectively so that we do not bring, people harm, and unintended harm, etc. But I don't think that it's a topic that we can leave unanswered. The infrastructure is there. There are, we do think that it could be both a symbolic and a technical tool. And I think we should implore the department to check and not just leave it like that, and give us a sense or a consideration for the pros and cons of reinstalling these electric fences. We know that the cost is high, but it would be interesting for us to be able to consider that cost-benefit analysis of reinstating electric fence, the electric fence infrastructure that we do have at certain key points of entry at the different border crossings. It would be interesting to get that type of report to hear what would be the impact thereof. So that would be my submission. Thanks.
Thanks. I'll come back to you, Honorable Nguban. What we may consider in line with this submission is to have a joint meeting with the Defense and Public Works. I'm raising it that members will recall that there was a joint oversight conducted by Defense and Public Works and Home Affairs there by Bridge in the 6th administration in relation to this question of the fence and related, because there are other related matter issues that are facilitated by this by the Department of Public Works. So in addition to that, without limiting to invite the Minister of Home Affairs and the Deputy Minister, but I'll propose that we have a joint meeting that we invite the Border Management Authority as an institution that mans the borders including with the related ministry, but it will be important that we invite the Defense and Public Works so that we deal with this matter. I'll propose in addition to this proposal by Honorable Ngobeni. Honorable Ngubane?
Thanks very much, Chair. In addition, on the BMA matter, Chair, as well, I don't know whether we can still get a feedback on that, the status of that fence that was erected by the Department of Tourism as well, that was paid, on how far it is, or that fence still exists, or is that place still has that fence? Because, Chair, the reason I'm raising this, there is this belief that when we speak about borders in this country, we always talking about only the cosmetics of it, on only freeways and the closest place to the borders. As you move far from the perimeters of the borders, it's just lines or it's just fence that a kid can jump or a cow can jump. So if we can get Chair at that as well, whichever departments has contributed in assisting our borders be the real borders, whether they succeed or they they didn't succeed, or whether it was a matter of trying to cash in or not, just to understand that how far are those assistants were and how far did they go. That's on the BMA, Chair. Chair, I would like to add as well, to go back to the government printing works, if you may, Chair.
I'll propose, let's if there's no any other matter on the oversight of the Lebombo, let me invite members to consider adopting the report, then we'll move to GPW.
Okay, all right, it's fine, Chair. I'll stop there then, if that's the case. Once we finish with this one, I'll speak about government printing works. Thanks, Chair.
Through the corrections and amendment made, can I invite hands to adopt the report? Honorable Ngobeni?
I move, Chair. Thanks for the adoption.
Seconded?
Supported, Chairperson.
Thank you. The report has been carried. Can we now move on the government printing works on the recommendation? I think Honorable Ngubane will be the first.
Yes, Chair. Thank you very much. On the government printing works, Chair, on the report, as I've seen it put in front of us by the writer, Chair, the emphasis that I'd like to come out clear, Chair, there are issues at government printing works where visibly it's on our face that there is no leadership. Day-to-day basis, we are bombarded by problems of government printing works. Every day, one of the recent, Chair, issues that I'm bombarded with is on Saturday, the 28th of April, government printing works experienced power failure. That was around after 12 p.m. afternoon. It continued following a day on the 29th, 30th, and government printing work was unable to print smart ID cards, passport, examination for students, and other printing works that was supposed to happen. The generator doesn't have capacity so that it can print all products. And there's no communication from management about what is happening about the generator. And this chair is happening on the Visakhe building. And this is a national key point. There's no backup plan. It's not functional so that the printing can continue. So why I'm highlighting, Chair, the institution is being failed completely on the day-to-day. As we write this nice report, that there's even a turnaround. People are being told, put a turnaround strategy. Do something. You know, Chair, there is somewhere where you tell your child, stop doing this, and you see an improvement from your child. Oh, this kid has stopped doing this thing, and there is improvement. There's some step that are pointing to the right direction. With this government printing work, there is not even an inch. And hence, Chair, I'm saying again, I'm emphasizing, the head of this institution is incapacitated. It doesn't know what it's doing. It doesn't know whether it goes left or goes right. We come to meetings after meeting, we say this, and they present, they're good at presenting. This is what needs to be done. But the following day, issues after issues pour in. We need to nail the pin in the head, Chair, that there is an incapacitation of the leader of this institution. They can't resuscitate the institution. It's finished. That's all what I need to come out here on the report. Thank you.
Thank you, Honorable Ngubane. Honorable Ross.
Thank you, Chair. Chair, I just have a concern in terms of recommendation 8.5. And it says that the GPW needs to address the increasing very high irregular expenditure. Chair, the irregular expenditure which was reported, the 1.5 billion, is from previous audits. So these are outstanding audit issues from a previous financial year. And here the next step was that the loss control committee, because there's a loss control committee that was appointed by GPW to finalize, they needed to finalize investigating and resolving the non-compliances from the previous financial year. So the way it's worded here suggests that this irregular expenditure is ongoing in the current financial year. But our resolution, and as we discussed in the committee, was to say that these previous audit issues must be finalized by the loss control committee. They must be investigated and resolved. Thank you.
Thank you, members. All the issues have been captured. That is a reflection of the previous committee meeting and your oversight you have conducted. You have identified issues. Can I invite hands for adoption the reports with the addition that has been made? Honorable Ngubane, sorry. Can I move for the adoption?
Sorry, Chair, my amendment hasn't been correctly captured.
Yeah, no, I'm noting to correct it with the amendment. We'll still have to rework the issues that you have captured it. Yeah. Can we move for the adoption with all the amendment that has been made on the report, Honorable Machi? Honorable Manchi?
Thank you, Chairperson. I move.
Move for the adoption with the amendments.
Yes.
Second.
The adoption with the inclusive of the amendments.
Thank you. Any seconder?
I second.
Honorable Ngubane, seconded. Honorable Ngubane.
Can I just make one assertion or maybe insertion, and I move that we adopt. However, I don't know where it will fall in the development with regards to the CETA, and how we were very clear in that oversight that there has to be a restoration of ICT systems and infrastructure, and that there must be stronger collaboration between, or cleaner, more governable sense of collaboration between the CETA and the GPW. But the recent developments with regards to the state of affairs at the CETA and whether the CETA is going to be privatized or not, I think we need to find a way to mention that as a result, as a recommendation, that we would like to get a sense as to what that development will mean for GPW, because that doesn't come out very clearly. And the issue with the CETA and the GPW relationship, as Honorable Ngubane was mentioning with regards to the governance and all other issues we experienced at that oversight, needs to be captured and made very strongly here, so that when the executive comes to account, they need to be able to take us into their confidence with regards to plans in this regard. But I move that we adopt the report. I think it is a true reflection. I just wanted to make that point of emphasis. Thank you.
No, thanks very much, members. We'll deal with I think it's a matter we'll will also reflect it in our reports. We have been briefed that the security cluster in particular, not in particular, the security cluster, which Home Affairs is part of, must be no longer use the CETA, and there's supposed to be a piece of legislation to that effect, which also will include government printing works. And this is a decision that was taken by members of the committee in this, also in this seventh administration. So we may need to reflect it, Mr. Matonzi, Mr. Salmon, in relation to this CETA, that Home Affairs must be exempted for using that. On the developments that are current, I'm not sure. Perhaps we may need also to find an expression when we interface with the subject matter at the time that we interact with CETA. But in particular, the decision that the sixth administration have taken, that security cluster must be exempted, which was affirmed also by this committee when we're discussing the power failures and these related issues that have been raised by the committee. So with that, 2 reports have been adopted with the amendments that have been made. Is there any other item, Mr. Matonzi?
Sorry, Chair, I was muted. Then the other issue, Chairperson, is the issue of the reports on Ms. Bulelwa from Mthatha, and the issue of Stephen Dion from the PE office. Could I go ahead and report, Chair?
Proceed, Mr. Matonzi.
Yes, I've emailed the reports that came from the Minister of Home Affairs in terms of the Ms. Bulelwa, and then I made a follow-up with her last week on Friday. She did indicate to me telephonically that the Department of Home Affairs invited her on the 22nd of April to come to the office to conduct an interview. Then there was somebody from the national office who was there from immigration. And then she indicated to me after that interview, they told her that no, they are going to send the report to the head office, and then should be waiting for the department to contact her. And then yesterday, I engaged with the provincial manager who gave me a report on a WhatsApp to indicate that they've contacted her yesterday because they finalized the investigation. The investigation found that no, in fact, the marriage was fraudulent, and then they've asked her to come today to sign a DHA 15 form for the cancellation of that fraudulent marriage. That is the report, Chair, but I think I'll also follow up by the end of this week if she has gone there to sign that form to cancel that marriage. And then on the issue of the Mr. Stephen Dion, I did call that number that was provided in the report. The number does ring, but no one picks it up. I think that was what the department also indicated, that no, they called the number, but the number is not being picked up. But in relation to the lady who's married to Mr. Stephen Dion, she was contacted, and then she could not show any cause why she should not be deported, but she opted for self-deportation. And then they provided me here with a passport number that she left on the 9th of April via OR Tambo. So she has left. And then with regard to the divorce decree, has not been submitted by Mr. Stephen Dion Prince. He has not submitted that divorce decree that he did in Israel. So that's all, Chairperson. I'm sure the other issue of Mr. Phil Craig, there was no follow-up that I could have done regarding that matter. Chair. Thanks, bye.
Thanks, Mr. Motsu. When you say bye, you're leaving the meeting.
No, I'm saying I'm not leaving the meeting.
Okay. I think what the exercise, what we want to, before members come in, the intention of this particular matter of, let me start with this one of Western Mthatha. It would be important that because there may be, or there are many who are involved in fraudulent marriages. And wanted to demonstrate on this case to the public how Home Affairs or the committee has dealt with this matter. It was going to be important that we had prepared a brief report that at least you're able to demonstrate when did we interface with this matter. And I know that it was almost 15 years or so this woman has been struggling. And the stages in responding to this question of fraudulent marriages. I know that I was engaged with Asikhulume in relation to the same matter with 2 or 3 women who were found to be fraudulently being married. So I will appreciate that in the next session, because the public also must also able to benefit from the process we're engaging on it, and prove that these are the stages that we've been engaged on, because the reason that I requested the committee team to investigate is that the response from the minister that this matter is receiving attention is not sufficient to the committee members and the public. That is receiving attention, but there's no demonstration what is sufficient. So your verbal report must be accompanied by a report that has at least been flagged here, and I request that we sit on this matter until it's being resolved. We're able to deal with some of the issues, and we must encourage those that are fraudulently married. And if it's found that in the line of function, there's people who in Home Affairs has been involved on this matter, they must also be identified, and also consequence management must kick in. So that is the reason that we need to follow this matter to the latter, so that we're able to assist all South Africans on there's somebody who has facilitated this matter in the past 15 years, and we must get into the track of this matter in Mthatha. We are not going to leave it this matter. So I'll encourage that in the next session you deal with this matter, including the matter that of this man who found was trying to facilitate a marriage on the person that has conducted a self-deportation. There must be a process to find this chap, and you'll know that the sequence of events emanates from Israel in relation to the this chap that we've found trying to facilitate a marriage. On the matter of Phil Craig, we must take it back to the minister that we need a detailed the report in how it has been crafted. It may appear that it's just a by the way responses in all the matters, that 3 issues that have been raised. So we must refer back this matter to the minister to give us a comprehensive detail on the issues that are involved on this individual. Can I invite Honorable Ngoben? I see your hand, and Honorable Mukhale. Honorable Ngoben.
Thank you, Chair. You know, I fully agree. You know, the issues of fake marriages, all of these things are of great concern. But I do want to zoom in on the Phil Craig matter. I think that, you know, as a committee, when we are sitting here, all of us, we act as one. You know, we are here in the interests of the people of South Africa, and not necessarily our individual organizations that we represent on this committee. I think I fully echo and I agree with your sentiment that the minister cannot give us a half-hearted answer on this in this regard. There was huge furor when we had the Chidima Adetshina issue, and she was attacked by the entire society for that matter to be resolved, to be communicated to the people of South Africa, and in an instance where she was a child of somebody who was undocumented, and we know the story of what happened with Chidima. But there is absolutely no way that we can accept a half-hearted response from the department, particularly the minister, who has the powers to confer or accept somebody's plea for citizenship or lack thereof. Now, I doubt that Mr. Phil Craig passes the citizens test. And I think we need to push the minister as a committee and not as individuals to give us an unequivocal response as to what it is he's going to do with the Phil Craig. Craig's application is sitting on his desk, and what are his thoughts around affording such an individual a citizenship in our country? You know, the interesting thing about Phil Craig is that he is applying to be a citizen of a republic that he does not believe in. We do not currently have the Republic of the Western Cape in this country. And I think we need to be very, very, very unequivocally clear to the minister that he owes this entire committee and the people of South Africa a very well-considered and clear response. The fact that it's in process or whatever the case may be, it's not something that we should tolerate as South Africa. And the fact that he is a British citizen just reeks of and promotes this thing that, you know, South Africans are xenophobic when we are not. I think Phil Craig needs to be made an example of, and a very strong example at that. And the minister must receive a very strong letter from this entire committee. And not just from each of us individually. I think he needs to come back here and account the very same way that everybody went after Chidima when her matter was on the table. I think, Chair, that we must not leave this matter to linger, because it is happening, and this individual is participating in the political processes of our country, which is in and of itself illegal. We need to know the Cape Independence Movement. Who is it registered under? What does the IEC have it under? Where is it? Where is the information? Who is this guy? How long has he been here for? And where is it that he's residing? We need to know what exactly the department, including the Home Affairs Department itself, with regards to the status of Phil Craig. And we need a full answer with regards to who this matter is and how is it that he's contributing to the advancement of the Republic. There's absolutely no way that we can tolerate people who want to be in this country to divide it and also to advocate for some kind of balkanization of our country. It's absolutely unacceptable. And I think we need to make the minister understand that without any fear or favor. Thank you, colleagues. Thanks, Chair.
Thank you, Ngobeni. Mokhale.
Thank you very much, Chair. First of all, I don't know, is there a written response or report, Chair, that we're dealing with regards to these issues? Because I see that Braedi was reading something, but I don't have anything on my side that I can refer to as a report or response from the minister on these issues. Then secondly, Chair, I think I agree with my colleague that we really should send a very strong message to the minister regarding this issue. That is unacceptable, Chairperson, that the committee has to wait. I mean, this matter has been raised over a month now, that this issue has been raised with the minister. In the previous committee meeting 2 weeks ago, when he was supposed to come and respond to these issues, he did not attend that meeting. Well, we understood he was in Lesotho for a bilateral meeting that side. But Chairperson, it can't be that till now we don't have a clear answer as to the status of this particular individual in South Africa. Chair, what I also want to raise is that the spokesperson of the president, he made in one of the he was giving, I think, a media interviews that he was conducting. He is the one who commented on the status of Mr. Philip Craig in South Africa, that he has a permanent residency. But when we ask the minister, as members of this committee, through written questions, to respond to us, to provide clarity on the status of this person, the minister tells us about Paya, The minister tells us about POPI Act and all of those things that limit our access to this kind of information. But my question was, how then did Mr. Mangwenya know about the status of this particular individual when members of the committee themselves, they don't know whether this individual is a citizen, holds a permanent residency, or whatever his status might be. So that is one of the questions that I personally have written to the minister, and up till now, Chairperson, I've not received any form of response to that particular question. So, Chairperson, a strong message, a letter must be sent to the minister that in the next meeting of the committee, the minister must be here with a full report on these particular issues, Chairperson, to come and tell us about this person. We want to know, Chairperson, we want to know whether this guy is a permanent resident of South Africa. If he has applied for citizenship, we want to know whether that citizenship is going to be given or not. So those are issues that I believe, Chairperson, we must raise very strongly with the minister. And then lastly, Chairperson, I raise this, Chairperson, with great sadness and sorrow that over 3 weeks ago, I submitted an issue, a query to the Department of Home Affairs from a member of the public. It's been 3 weeks now, Chairperson. I've not received any response from the department. I mean, if I, as a member of parliament, can be frustrated like that for 3 weeks, Chairperson, I've asked you to intervene, Chair. I think I sent you a message last week because of the frustrations that I had encountered on this particular issue. As I sit here now, Chairperson, I still don't have any response from the department regarding the query that I submitted 3 weeks ago. So we can't accept that, Chairperson. That cannot be accepted. We are members of this committee. We are members of parliament. When we raise issues with the department, when we submit queries to the department, they must be given attention to. They must be responded to promptly. We must receive those responses so that we can go back to the people who send us those queries and give them those responses. And the people who come to us, Chairperson, they don't come to us because they want to jump the line. They want to jump the queue. They come to us because they are frustrated. They've been interacting with the department for years or for months without receiving any responses from the department. So, Chairperson, I am requesting you, Chairperson, that this query that I personally submitted over 3 weeks ago, I need a response on that particular query. Thank you very much, Chair.
Thank you, Honorable Mohale. Honorable is a legacy hand, Honorable Ngoben. Mr. Matons, who's the last?
Mr. Ngubane.
Oh yeah, Honorable Ngubane.
Yeah, thank you very much, Chair. Again, I think, Chair, we must be decisive as this committee. Minister must not take us for a ride, Chair, especially on the issue of Mr. Phil Craig. We need to put the deadlines, the date of getting a feedback from the minister. Probably by Friday or whenever, we need the deadline of when are we getting a full report about Mr. Craig. So this is where, Chair, we start being a banana republic. When other people are able to be disclosed because of whatever race they belong, but other people, when they are questioned, they're being treated like a soft glove. So we need to put deadlines, Chair, to the minister about the report of Mr. Phil Craig. And the second point, Chair, on the issue of Ms. Bulelwa Toyana and Mr. Stephen Dion, I'm worried, Chair, as a committee, we are now on the feel-good syndrome, Chair, where we now feel good. We've solved 2 problems. Hooray, yes. These were the problems that we met on our oversight, and we've done very well. We've solved so many problems. We're doing great as a committee. I can tell you now, Chair, Mr. Mohale have said this, Honorable Mohale have said this, Honorable Ngubane have said this. These issues that we are realizing that we've received in this committee of Mr. of Ms. Toyana and Mr. Dion. There is hundreds of them that no one knows about them, and they are left unresolved. I guess, Chair, as a committee, let's devise an overall solution for this, because we're gonna, as we move on to the next oversight committee, we'll pick up 2 bits and pieces of problems. Boom, the Home Affairs will jump into them, resolve them. Oh, we're doing good. I can tell you now, last week, I think I've forwarded 3 issues with Home Affairs, and where I've picked up the loopholes on their converting to online system where people must do things for themselves. There's a loophole on that issue, Chair, where a person sitting at home interacting with a computer now gets some way of cooking the system to make things work for them in comparison when they are faced with when they're at the Home Affairs offices. There are many loopholes as we migrate to a digital Home Affairs. There are issues about that. And immediately I've picked up the loophole, and the guy at Home Affairs said, oh, there's an issue here that they need to put a rule to avoid these things. What I would like us to do, Chair, as in Home Affairs, let's, number 1, get an answer from Home Affairs. Do they have a customer relationship management system? If they have it, how many issues have they received? How many time to attend to those calls? How many were resolved? And how many have never been resolved? For example, Chair, now, I've just found that 0800 number for Home Affairs. It has a voice note that says they are opening from 7 to 4 on Sunday. They're opening on this date and this date. And then after that, it kicks me off. And it did this 3 times. And I phoned this 0800 number, and I never gotten through. Now there's an issue. Millions and millions of people have gotten tired of Home Affairs, of calling them, of registering their call, because their calls, number 1, are not attended to, and number 2, they just go into a dark hole. And they stay there for 5 years, and not even stay there. No one cares about resolving them. No one cares about our people. Even people who want to know whether I'm married or not married. There's no way. So there's an issue with customer relationship management at Home Affairs. Let's get that whole statistics and even a demo of that system, that when they log call, who is it attached to, the person who resolved that issue, and how they follow up. How do they phone back to the person who logs the call to tell them of the status of their call? Because people don't even get the feedback of the calls they've logged with Home Affairs. So that's a challenge, Chair. We need to know the CRM, customer management, the relationship management with Home Affairs, and where it is and how far it is and who's dealing with it, if it exists or not. And this 0800 number doesn't work. Thank you, Chair.
Thank you very much. Any other comment? DDG Acting, do you want to comment?
Chair, I have no comment, Chair, at this stage, but I've noted all the comments from the members, and I appreciate the comments as well. I will relay the comments to the DG, Chair, as well as the previous presentation on the matters that the Portfolio Committee has raised. Thank you, Chairperson.
Okay.
Chairperson,
Mkhale?
I thought the DG was going to tell me when I'm going to get my response to the query that I submitted.
The Acting DDG, let me assist that, and I want to recap that the reason we wanted to deal with this matter of Mthatha is a demonstration that there are South Africans who approach Home Affairs day in and out and are not assisted. And we did reiterate that point during the public hearings in the presence of the acting the DDG Mavuso and provincial manager, that matters that must be, or South Africans who are frustrated, they must not rely on a councillor or provincial legislature member or an MP for their matter to be attended, to pay attention, because this matter has been brought by MP or councillor or MPL. But the system itself must be appreciated by all South Africans. And that's the case we're trying to bring to the attention of the department. That if members of parliament across, or members of the provincial legislatures and councillors are frustrated to facilitate matters raised by the community or any other individual, it becomes a problem. And the principle is that when we raise matters with the department, we don't want them to be facilitated or accepted in relation to past documents. No. Is to allow or create an opportunity or environment where the client or a member of societies complain or want to be assisted, the department must facilitate it within the framework of the law, be approved or declined. But there must be a case of accountability on the both sides in terms of facilitating the client. So that is the only thing that the public representative, and this, when they are stuck, they come back to us. We have a lot of, and I think I agree with all members that all of us have cases that we are sitting with that are not being attended to. And I think the norm that always want to call the DTGs or DG that this matter, and I think it's not fair for members, those that are frustrated or are unable to reach out, or they are unable to reach us as members of parliament, including members of this portfolio committee. So I think we need to draw attention to that space, that we're trying to build a case that we've been raising over time, that there are issues. For example, acting DDG Yusuf, a person writes an email on a query is being responded after 2 months or so. That is this case. The matters of the visas that takes longer, and there's no accountability around that question. So I want to draw that attention to you as you pass that, but we'll formally communicate to the minister, and also invite the DTG Civic, Mr. Sigama. And it also be important that the department must go out on outreach to talk to the members of the public in relation to a subject matter that members are complaining about. And I think these are immediate issues that we need to engage with members of the public. We've raised this matter in a strategic plan when we're presenting it. That Deputy Minister, you must go out on imbizos or outreach, create a platform on the particular items, fraudulent marriages, how we're going to deal with it, what are the issues, and so forth and so on. So, and this is an important platform to be utilized. We must not appear on TV when we deal with the modernization or digital transformation. It must be also amongst the issues that we have been frustrated both in urban and the rural area. So what we're going to do, the first point is that in the next meeting, next Tuesday, Mr. Matonsi, we need a full report on this matter that were raised. What you have reported, we need a comprehensive report on the cases of Mthatha. We must understand why the query was raised, the stages that have been taken as we interact, and DDG Sigama must fully present those reports to us. Secondly, this matter of Phil Craig, in the next meeting, we need also a full report on this report that was saying. In other words, the reasoning that I've directed that you must go back to investigate against this response that we've been presented by the minister. It was to make sure that members of the committee and also are satisfied on the process that is being engaged, and also give other members of the community to communicate with us. So in the next committee meeting, Tuesday, these 3 reports, we need full responses, and we'll communicate as such to the ministry. Can we then close this matter in that manner? Mr. Mthatha, is there any other item?
Chairperson, sorry, no, there's no other matter except that for this coming Friday, we're scheduled for a meeting, which I think will not take place because there's many plenaries that are starting at 10 o'clock. So, and then also for next week, in addition to what you indicated, Chairperson, will be dealing with the issue of the immigration bill that we dealt with today, and then also on the issue of the counter-corruption and security services on its with the committee on its work on to curb corruption and fraud. And also for this Friday as well, we're scheduled, Chair, to have a briefing by DMA on the Easter festive season report. So I'm not sure if we move it to the 13th, whether the agenda will not be crowded. So maybe we can move it to another date, Chair. That's all for my side.
Okay, Mr. Salmon.
Thank you, Chair. Yes, we've also got the draft strategic plan of the committee scheduled for this Friday. I have a provisional plan, but it is dependent to an extent on the strategic plans of the department and its entities. So we may need to postpone that one, but we can't postpone it too much because I think it needs to be completed prior to our international travel plans being approved.
Okay. I think what we communicate to this meeting to members that members have adopted a program for the year, and our program in any other committee, I think there's going to be disrupted by the changes of the review of the budget. And as you have recalled that we were supposed today to deal with IC and GPW. So we're going to change our program and in relation to, it's going to change in relation to the subject matters that we're going to deal with. So we'll communicate, I think these issues that we've carried will reflect in next week Tuesday. Friday is the mini plenaries. There's not going to be a committee, and obviously it impacts on the items that you're supposed to deal with. So I think let's leave it at that point and note that they will work changing the program as we move forward, given the issues that we're dealing with in the budget and the matters that we're raising. Mr. Salmon and Mr. Mthatha will reflect that in the MENCO and refine in consultation with the chair of chairs on the key issues that the committee may need to deal with. Let me thank members and the Parliamentary Legal Services, Chief State Law Advisors, Advocate Malekate and Acting DDG Youssef, and all honorable members and officials for having attended and contributed to all this meeting. And thanks very much. We're now going to plenary. The meeting stand adjourned.
Thank you very much, Chair. Bye-bye.
Thank you, Chair.
Thank you, Chair.
Everybody, bye-bye.
Thank you, Chair.